My name is Adefolahanmi, Onanuga, student ID 2209758. The question is a critical comparison of the duties and immunities of a carrier under the Hague rules, Hamburg rules, and Rotterdam rules. The intention is not to have multiple conventions governing the carriage of goods by sea. The Hague rules came into existence on the 21st of December 1979, while the Hamburg rules came into effect on the 1st of November 1992. The Rotterdam rules is yet to come into effect, as the 20th nation, as we understand, is yet to ratify or sign it. These rules have different provisions that govern the carriage of goods by sea, and we've realized from the Hague Visby rules, which is the first in line, it is an update of the Hague rules. It's the first in line, and then we have the Hamburg rules and we have the Rotterdam rules. These rules have tried to improve on themselves, which is the Hague Visby rules is an improvement of the Hague rules, while the Hamburg rules is expected to upgrade or update the Hague Visby rules. Same for the Rotterdam rules, but as it is now, most of the nations concerned have not ratified, and we did not ratify it. Some have ratified the Hague Visby rules, some have ratified the Hamburg rules, some have ratified the Rotterdam rules. So the liability or the Hague Visby rules comes into effect when there's a bill of lading or any document to that effect, and where it is for carriage of goods by sea between two states, then it would apply where it is for where you're lifting, you're loading, or where you're discharging, or where that's a contracting state, and then or where it is stated in the bill of lading that the Hague Visby rules would apply, or that the rules or laws of a contracting state would apply. There's a slight expansion on the Hamburg rules, which is also for the contracting state where it is loaded, port of loading, port of discharge is a contracting state, or there's an optional state that is included, and that state applies the Hamburg rules, then the Hamburg rules would apply. If it is stated on the document, the contract of sale or the bill of lading or contract of carriage, then it would apply, or where the laws of that particular state, or where the bill of lading or the contracting document is prepared, then the Hamburg rules would apply. The Rotterdam rules is an extension or an expansion. So this goes to where the goods are delivered, then the rules of, if it is a contracting state, it would apply. Where it is loaded, if it is a contracting state, it would apply. Where it is discharged, it's a contracting state. Where it is delivered, it's a contracting state, it would apply. Now, the goods by that are under some of these rules, the bill of lading covers all goods, but it doesn't cover goods carried by deck. Covers goods, it does not cover live animals. Where it is stated for the deck goods carried by deck, it must be stated in the agreement, and it must be so carried on the ship, on the deck of the ship. For the Hamburg rules, it applies to all kinds, and then by extension, which is why it's always been a development of the problems they've had in the previous one. It provides for carriage of live animals, but it has provisions for that, and it applies to carriage of goods by deck amongst carrying normal goods by sea. The Rotterdam rules is also the same, an expansion, carries all kinds of good merchandise, live animals, and goods carried by deck, where it is stated on it. Now, the responsibility period for each of this one is also of the rules. There's also an expansion or from one to the other, wherein you have tackle to tackle is what the normal saying under the Hague Visby, that is from when the tackle of the ship picks the goods up and then the tackle drops it at the port of discharge. That's the responsibility period. For the Hamburg rules, it is from port to port. That is from where the goods are in charge of the carrier at the port until when it is dropped at the port and it is no longer in possession or care of the carrier. So that's port to port. While for the Rotterdam, it's an expansion to the extent where it is from door, it is stated to be door to door, moving from the place of delivery or where the carrier accepts it to the port, and where it is going to be delivered beyond even just discharge at the port to where it will be delivered to the consignee. Now, the Hague Visby Rule provides under Article 3 for the duties that the carrier must exercise due diligence in making the ship seaworthy, cargo worthy, that is to carry the goods, to be able to preserve the goods, must take care in stowing, carrying, loading the goods, that's tackle to tackle, and must not deviate. Man must carry the goods with dispatch. The only time they can deviate is when it has to save a life or save a property, and it has to be reasonable. For the Hamburg rules, it is from the time from the port. The liability for the Hague Visby rules is from and before and at the beginning of the voyage, while for the Hamburg rules, it is from the port during the carriage and self-discharge, while for the Rotterdam rules, an extension as always from when it has been accepted by the carrier. It is in charge of from all the way through when it is delivered, not just tackle to tackle or door to door, as it were. And the liability, then there's a part where the documents also must be provided for. That's a duty for the under the Hague Visby rules, must provide the bill of lading stating certain things. That is the details of the goods, the packaging, the quantity, the packaging, and the identification, quantity, any inherent defect. This is not. This is also provided for in the Hamburg rules, with chapter Article 15, wherein certain things must be stated, like the name of the carrier is always an extension or an expansion. So it has to state the goods, the carrier's details. Same for the Rotterdam rules, which must include all of the marks, the inherent details of the property, the carrier's details, where it will be delivered, so that the full specification and details of the goods is well known, and they are responsible for the goods to be delivered on time, no deviation, unless to save a life or reasonable effort to save property. Now, for the liability under the Hague Visby rules, they feel it is a bit of an escapism for the carrier, because the carrier would only be liable if he fails from making the ship seaworthy, cargo worthy, and they didn't carry it very well, and that is at the beginning. If the carrier has done all of that, there's going to be a difficult development for the shipper to prove that the carrier has defaulted. While under the Hamburg rules, there is a uniform set of rules developed, and it is adopted for the liability of the carrier. There's a presumption. Precisely, there's a presumption. That's where presumption was introduced. Same was carried on in the Rotterdam rules, that there's a presumption. Once you're carrying the goods, there's a presumption that the carrier is liable for anything that happens to the good, from loss, damage, or delay in delivery, unless the carrier can show that in their capacity, while they did not contribute or do anything at well. So meaning the burden is on the carrier to show that the loss or damage or delay is not a fault of his agent or any other person who's acting under the instruction of the carrier. And it was extended in the Rotterdam rules beyond all of, and most of the cases that we've dealt with, if you see that in Albacora case, the sea unsalted fish, where you're caught by the Hague Visby rules, or there's a liability, there's hardly a way you can extricate yourself from the Hamburg and Rotterdam rules. They are an extension of the entire thing beyond what the Hague Visby rules are. And there are immunities, and the immunities are a bit endless. There's no set of immunities under the Hamburg rules, but they've stated that where it is for fire, and they can show that they didn't do anything to cause the fire, the agent, and even when there was a fire, they did all that they were supposed to have done to put out the fire. They were diligent, and by extension, where they have to save a life or reasonable effort. So it's not a blanket protection. And then again, for live animals, because it is a risky carriage. So they're given a very relaxed, but it doesn't mean if they can be found that they did not do what they were supposed to do, or the instructions they were supposed to carry, or what they had agreed to do, then they will be found like. But if they have complied with it, there's a relaxed form of protection for them in that regard. For the Rotterdam rules is also, sorry, for the Rotterdam rules, there's an extension of it to the extent where it has the same rules or same immunities with the Hague Visby rules, but then it has extended it to riots, to seizures, to provided all of this is not connected or related to the fault of the carrier. Now, in essence, when put together, the Albacora case, the Pyrene case established the liability period, and we've also got the case of the marine Magazine Footwear and Canadian government, so where there was a fire. So in that case, the one of the workers, what the method they used in trying to sort out the problem that they had with the cork, with the a frozen pipe, it led to a fire, and it was at the time they were loading. So under the Hague Visby rules, they were caught. So if it's from tackle to tackle, you're already caught under the Hague Visby rules. It therefore means that there's no how you'll be able to, you'll be liable under the Hamburg rules and Hague Visby rules. So at the end of the day, we can see that it is quite an important area of law sorry, the role of the carrier is very important. And this is why all of this majorly will rest on the carrier, and that's why there's been an improvement to expand the level of liability, though as well as maybe from protection, but the level of liability and the number or the kind of carriage that can be goods that can be carried by sea, from the Hague Visby rule to the Hamburg rules to the Rotterdam rules. Thank you.